Hello, everyone. Welcome back to another episode of the Divorce Differently podcast. Now, has your ex been gambling away all your savings? Or are they going on lavish trips with their lover? In divorce proceedings, the concept of poor conduct can feel very confusing because a lot of people expect that the system is going to take that into account. But actually, in the context of no-fault divorce, there's only certain behaviors that carry enough weight to have an impact in how we divide finances and assets. And knowing what matters and what doesn't matter can really make a really important difference in how you're going to broach the conversations with your soon-to-be ex and negotiate your agreements. So in this episode, we're going to break down what conduct really means, how it's assessed, and also when it is worth raising. So to talk about this, I've invited Naushaba Awan. Naushaba is an associate at JMW Solicitors, and her experience of family law includes financial proceedings following divorce or the dissolution of a partnership, as well as jurisdictional disputes on divorce. Having studied at Sciences Po in Paris, Naushaba speaks French, and she can assist many of my clients and many of you out there in advising francophone clients. Thank you so much for joining me today.
Oh, thank you. Nice to see you, Chloe.
I am looking forward to picking your brain because this is a topic that comes up a lot. I think we've all seen cases where somebody has misbehaved, and there is an assumption that the justice system renders justice on those elements. So to start with, there is that technical term of conduct. Can you explain a little bit what conduct means specifically in the context of financial proceedings?
Yeah, of course. So, yeah, I think to the man on the street, you say the word conduct, they're might look at you a bit oddly, but it is a word which is bandied about quite a bit. And you'll see it on a Form E when you fill out the financial when you fill out the financial statement on in the financial proceedings. Historically, the reason conduct, i.e. behaviour of the other party, was important is because divorce, since the mid-19th century, has effectively been based on conduct. So it was a very important part of the jurisprudence in this country. In the last 40, 50 years, times have changed, and now, and certainly in the last 4 years, times have certainly changed. When one divorces, there is no reason you don't need to cite any unreasonable conduct on regards the other party. It's simply the irremovable breakdown of the marriage. Now, that's obviously does cause a bit of confusion because you do come to fill out a Form E, and you will talk about conduct, and people will still feel aggrieved when they talk about their ex-partner and what they went through during the marriage and during the separation. When the law says conduct, it's looking at sort of 3 different areas and the behaviour. Why would you taken into account in a financial settlement? So the first one would be the obvious one, bad behaviour during the marriage or during separation. This is one we'll probably concentrate on quite a bit in this podcast.
Yes, because it's a loose term, bad behaviour.
Exactly. And there are so many examples of that. There's also litigation misconduct. Again, sounds very like a legal word. What that means is your spouse effectively either is fraudulent in terms of disclosure, doesn't disclose properly their financial resources, delays court proceedings, thus increasing your costs. That's one aspect of conduct. And the third one, it would be, and I'm really very broad here, is around dissipation of assets, i.e. during the marriage, did one spouse wantonly, and that's a very important word here, wantonly dissipate the family assets such that those should be added back into the overall settlement on divorce. So that's quite a lot of information there, but it is important because, let's face it, people's marriages break down for very often very, very difficult reasons, and there's a history of things which have happened in the relationship. And the reason, what we want to talk about today, I understand, is particularly personal conduct, and that, let's say, is a very, very evolving area of law for the man on the street or woman on the street. It is evolving, and it's hard to be categorical in terms of what will be considered bad conduct in terms of looking at the financial settlement.
Yeah, because I think that's something that comes up a lot in, specifically when you're thinking of domestic abuse situations. Is that something that should be raised? And I work with clients on their Formies on a regular basis, and some people will say, oh, my ex has been really nasty to me in that box, and it's understanding how to define conduct. So, what type of conduct actually has an influence in terms of how the finances are divided?
Nowadays, when one talks about conduct, and like I said, this is an evolving area. It needs to be egregious, i.e. a very high exceptional level of bad behaviour on the part of
Yeah.
one spouse. Now, the case law, we have only one Act of Parliament in relation to conduct, and that is the Matrimonial Causes Act 1973, Section 25. And conduct, the behaviour of a party, is just one of many factors that a court will look at when they're looking at the financial settlement. They look at earning capacity, health, and there's no one factor which has more weight than another.
Yeah.
But conduct seems to be the one that is the hardest one for people to really deal with when it comes to divorce. The reality is, and I would say with any client that comes to me, is that it needs to be of an exceptional level in order for us to plead it. And when I say plead it, I mean to put it before the court or to put it into correspondence with the other side. Because the case law is fluctuating. The most recent case was reassuring for those who are victims of domestic abuse and coercive control behaviour and economic abuse. And that was a case in late 2025. Effectively, the egregious behaviour of the wife was such that the rest of the settlement needed to be looked at through that lens, i.e. her terrible conduct. And, and so we do know there are examples where it does happen. But I suspect hers were particularly bad. There'd already been a finding in the children's proceedings of domestic abuse. So the judge in the financial proceeding already had that, and there were also ongoing criminal proceedings. So it will have a bearing in terms of the future. And her settlement was impacted by her behaviour.
And so in that case, is the expectation that the conduct has a financial implication? Is that required, or can, horrible conduct, even if it doesn't have a financial cost, be a factor?
It has to be a financial impact. That case was unusual. They said it wasn't measurable. It's helpful for there to be a financial consequence for the case, but it's not always measurable. And the judge in that case was very, very concerned that victims of coercive and economic abuse would not see justice, as it were. So it was effectively, it was a punishment for her behaviour, the reduced reward. She could still meet her needs, and that's an important part of this. And there were significant assets in play, so she could still meet her housing needs and her income needs, but they were not generously interpreted. And I know that, again, is a bit of a legal phrase there, but the English and Welsh court will look at the starting point has to be needs. They will always trump everything else. So they can't leave a spouse in the predicament of real need. However egregious that party's behaviour was. And like I said, that case was unusual because there were a lot of assets involved, and they spent significant sums on legal proceedings as well.
Oh, wow.
We're talking over 800,000, I think, in the children's proceedings alone. So there were significant sums, but let's face it, the person on the street will not have that kind of resource. And you have to tell your client and your clients, what are they going to, compensatory or punishing award to the other party may not be possible when there are just insufficient resources to go around.
So what would be examples of a conduct that has a financial consequence? I mentioned at the beginning gambling. That's one that's come up a few times. With clients whose exes have a gambling problem and went ahead and spent all their savings on in the casino or whatnot. Would that kind of conduct be something that you would look to potentially position?
Certainly always consider it. And I think I should say that from the start. Any client who comes to a potential inquiry, always talk about it, but you want to be real. You want to tell them about the limits and the discretionary aspect of the legal system. Gambling's an interesting one. There are cases where where a partner who has effectively dissipated assets, again, rather legal word, spent the money, it has been added back.
Yeah.
Also been cases where it hasn't, because the judge will say, A, there's needs, the person needs to live. B, the gambler didn't do it to deny the other spouse money. The intention behind it wasn't to deprive them, so it wasn't sort of economic abuse in that sense. It was an addiction, and they're seeking help for it. So we have fluctuating case law. There's also an very interesting case, and it's one which is often cited, where the man, a very successful businessman, had spent significant amounts of money on drugs and sex workers.
Yeah.
And he was not, in a word, punished for that. Because the judge said, we take people as they come. We can't start. It's not a moral order, a relationship.
Yes.
Take people as they come. He's highly flawed, but he's also highly successsul. I'm paraphrasing slightly the judgment there, but the man was highly successful. The wife had benefited from his success, his entrepreneurialism. Likewise, and the judge said many highly successful people are very often highly flawed, and that was the case with this particular husband. So it's very difficult. I realise as I say this, for anyone, one of your friends, one of my friends, those around us, when they come to you, you can't say to them categorically. But I would say there's a shift. I would say there's a shift at the moment in the court, and it's been discussed, domestic abuse, and that sense of injustice at the end of a marriage, and someone pay, the reward being greater for the victim. It's been discussed, it's moving, but it's not there yet.
And I think I can see it quite clearly when there's a financial implication to the domestic abuse. I've had quite a few clients where they were put on a stipend, or I had one where the husband was taking out loans in his wife's name and spending all the money and leaving her in debt. So those kind of situations, I would assume there's more of a correlation. That the issue that they're punishing is not the domestic violence itself and abuse itself; it's the financial impact of that abuse, right?
Yeah. And that's one thing I'd say, if you can monetize it, and it's dreadful to say that if you can put a finger on it, then great. Yeah. We also know that the impacts are on a victim of domestic abuse, and in all its different forms, economic, sexual, physical, their ability to rehouse, to build up capital is highly diminished as a result of this. There's much more research coming out. Yeah. And we know, and their ability, to simply get on with life. So you can evidence it through medical assessment and GP records and psychiatrists. And you'd probably then, if you were coming to it and you're doing your schedule of outgoings, when you're going through the divorce and you're saying what your income is and what your needs are, you would probably have to include a provision in that area for your medical support. But does that really meet the picture? Does that really deal with the long-term effects? Because the effects of abuse are long-term and pernicious. And and the ability of people to just get on with their lives and build up capital again. We often know the perpetrators can often rehouse quite easily, remarry quite quickly, and once you've got two incomes, it's a lot easier. So I think it's so much bigger than we're able to really deal with in the courts. But we have a limited family court system. You will know this, Chloe, from your clients. I certainly know this from me. You file an application with the court. It could be 6 months to a year sometimes before things are really moving, and that leaves victims, male or female, in very, very difficult positions during that time. So it's not a perfect system by any means at the moment.
No, I think it's something that a lot of people struggle with, in the no fault system, because there is that sense that there is no emotional justice. If there are cases where someone might have behaved appallingly, sorry, and then the other person, just it feels unfair that it's not recognized, and so managing expectations is unfortunately a tricky bit of our job in that context. So it's good to know that there's a little bit of a shift, and potentially we're moving towards a direction where
there's a lot of work being done, and I think it's been discussed. But I think when I see what's happening, I was at a conference recently, or talking about it with someone recently, said that's a London judge. You could be out in somewhere outside London, and I'm not assuming that London is better, but you could be in certain parts of the country where they may not be aware of the and the effect of abuse on a victim. So I would say all along that it needs to be exceptional. And if you're going to plead domestic abuse, it would need to be exceptional, which is a horrible thing to say, because any abuse is impacting, and to even to qualify something. I think long term as well, one time is one thing, someone, being difficult, but we're talking about a long term and the impact that has on someone's ability to confidence. Like I said, you argue it through different ways. You might argue it through needs and the ability, your lower mortgage raising capacity because you can't work, so you need more money from the equity. So you may have to argue, and you have to be, as a lawyer, you have to be astute and perceptive and work out how best to argue for your client.
And are there times where it's, and I think I kind of know the answer to this question, but I want to tease it out from you. Are there times where it's strategically better not to really even raise those concerns about conduct in order to actually focus on finding a settlement?
Absolutely, yeah. I think you have to look at the biggest picture, and it's awful to bring it down to money, but it's risky. It is risky at the moment. Things are moving, but it is still risky. The threshold is high. You could have it thrown out at the first appointment, which is the first hearing in the financial remedy process. The judge may not feel that conduct can be pleaded. You need to do it right from the beginning. And you can also be penalised financially if you pursue something which shouldn't have been pursued. And that would be either in cost orders, i.e. you pay your spouse's legal fees for them having to respond to your allegations. And obviously that will impact on you. So you have to really, really think about it. And I think the strategic thing would be there to look at the bigger picture, look at the assets as far as you will know them. Because of course, if you've got a client who's X is a non-disclosure, that's going to be difficult. But you need to
Yeah.
build up a picture as much as possible and get it in early and read it. And have confidence, and recognize and advise a client. And if you really don't think it's going to work or it's going to be difficult to argue, then you have to be honest with the client. And explain again that it's a discretionary system, and that's can work in some ways.
That's where the challenge is.
Yeah, it's very it's hard. It's very difficult. I think that some parts of the judiciary are slightly late in understanding the impact that abuse has. As I said, it's also we feel slightly distorted because majority of the victims of abuse are women. Men are abused as well. But the law is indirectly discriminating against women by virtue of how we run our proceedings.
Yeah, no, that's a very good point, actually. In terms of even evidencing the misconduct, how I'm assuming that the bar is equally high, but how would you even go about proving that and quantifying it, as you were saying earlier?
So, as I said, it's ideal for there to be a financial consequence, but it doesn't always have to be. There have been cases where there hasn't been necessarily a quantifiable amount.
Yeah.
With conduct, though, I would gather evidence like GP assessment. If the victim has, not all victims will go to the doctor. They may not, but if they did, obtain assessments like that, medical records. Have there been talking about an abusive situations? Have there been call outs to the police? What's happened? What have those reports said? They all build a picture. And also, if it's someone who's financially been secretive, you would want to, when you go into the proceedings, and you'd probably want to be in proceedings because you know that via solicitor correspondence and negotiation is not going to produce a good result. You probably ask for 2 or 3 years worth of bank statements.
Yeah.
I mean, we all know that if you know how to hide money, you're probably going to be cleverer than that, but there'll still be some way of, you want to get a bigger picture, and you would need to have a client who really argues that for you, because it's normally 12 months, as it's 12 months, and it's unusual to be 24 or 36 months. And I'd also, in terms of more of a practical point, and it's not quite an answer to your question, once you're in proceedings, ask for third-party orders. If you know your ex-wife is not going to obtain that disclosure, is not going to make those efforts, you ask the court to make that disclosure order, i.e. ask the bank to reveal that documentation. It's tough, and you have to be, and I think that's the other thing as well. If you've been a victim of abuse or in a very difficult relationship, or you've just been ground down, some people may not see it as abuse, but it's been difficult. Going through all of it is difficult as well. It's another thing. Have you got the energy to actually argue these points? And that's where
the money as well. I've had a lot of cases where actually I bet you if that person had got a forensic accountant, they would have been able to prove their ex's misconduct. But goodness, the amount of money and time and effort that it requires, it's not always worth it for that person to do it.
And it comes back down to, again, the finances. And we all know, I know that there's an emotional cost to litigation.
Absolutely.
Financial, it's exhausting. People want out.
Well, that's the reason they're leaving in a lot of the cases, right? They want to move away from this person, and they don't want things to last forever.
And that's an important point, is that like you say, it carries on though throughout the process. It doesn't stop on separation. It continues, and it needs to be recognised. And yes, you can get legal services payment orders to fund your proceedings if you haven't been able to fund them yourself. There are exceptions as well, but you can obtain those. But again, they can be quite difficult, and the costs are really, really slashed. I mean, it's not. I would always say it's worth applying for one, but it can be difficult. You're justifying your costs in that sense, because it's not straightforward. And I recognise that. I'd always say to anyone who thinks this is, that they are really impacted by this and what's happened in their relationship, to see if they can get some sort of support elsewhere, financial support, whether and through charities, because many charities will assist.
Oh, that's good to know. Okay. So that's a good avenue for people to explore. You were saying earlier that people need to raise it early. Are you referring to actually including it in the Form E?
Absolutely, yeah.
And is it worth including even if you're not going to pursue that specific argument? Is it just kind of a guarantee that you can refer back to it later on?
I would say yes. I mean, maybe some practitioners will maybe say no, don't do it if you're not sure. If you think you aren't going to, or it's a possibility to do plead it, but know what you're going to say. Sometimes it's important for a client for you to state it, but you may never actually deal with it again. Because like we said, we now have a no-fault divorce. Many people welcome that. Some people are less enthusiastic about it, but there's no point at which to say, hang on a minute, I went into this committed, wanting it to work. and now it hasn't, and it's their point to say that, it's their opportunity. But as long as you advise your client, we can plead it, we can put it in there, and it is put there, it's a box, but it also says
Yeah.
exceptional.
Yeah, it does. Yeah.
Yeah. So it's we have to be, you have to be very, very wary of that. But the recent case law has said put it in early. There's been one exception where they pleaded at a later date, but I wouldn't go by that. I would generally say get it in early,
Yeah.
because it's to case manage, but it's expensive.
Yeah.
It's expensive, and that's
It
why the
is
court
absolutely.
to do it. Yeah,
And so really the best approach if for people who think that it's something that they want to include in their case would be to get an early assessment from a solicitor to try and understand whether there's a chance of
absolutely.
arguing that really.
I would say, it's worth spending that hour or two
Yeah.
that first time, and recognize it's going to be hard. But then, that's our job, isn't it? Yours and mine, is to fight for the client and to reassure them, and that's where we come in and
Yeah.
we take that on. But you can't underestimate the impact it will have on someone to do that, to pursue
Great.
that argument. And if it was one where I wasn't very sure, we'd include counsel as well. We'd want to make sure we give the client the best advice possible,
Of
because
course.
there are times when it's worth arguing, and there have been examples, but it's not every day.
Yeah. And it's not always as fair as it seems to the individual who's had that experience.
Absolutely, because I think ultimately the court isn't there to run a moral audit,
Yeah.
and
Yeah. I think
justice
that's
looks
important to
different.
understand.
Yeah, and
Yeah.
I can see that. I speak to a friend of mine recently going through a very difficult divorce, and her husband hadn't worked for years for various reasons, and she was questioning why on earth was he going to have her pension. But like the other way around, I would have been absolutely saying, well, you'd be sharing it with the other way around. This is good. It does protect people. You have to remember
Yeah.
there are reasons why it's there, but it's also not going to go through, as it were, the attic of the marriage, as it were, and start finding out who did what and who did what. Adultery is one thing. There are other ways to, you can't necessarily go down that road and criticize people. All sorts of things happen in a marriage, and we can't ever find out the whole picture.
Yeah. And as you say,
Examples of domestic abuse, and I'm not including them in that, but it's a lot. It's a marriage is a complicated, it's an ecosystem. I think I've read that somewhere. It's a little
that's a good
ecosystem.
analogy, yeah. And also, I mean, every couple organizes finances in their own way, and so it's very hard to, as you say, to pass a moral judgment as to whether that was abusive or that was just the way they arranged it.
Yeah,
And sometimes it's cultural as well. I've had a few clients like that where they, to
absolutely.
me as a Westerner seem very shocking and I would describe as abuse is completely commonplace in how it gets handled in certain places, and so
Yeah.
that needs to be factored in as well.
I would say the same, having known that in cultural settings. I'm very familiar with
Yeah.
that sense of
Yeah.
one person running everything financially. And it's more acceptable in some settings, but it has its own challenges. So.
Just I don't want to go down a rabbit hole, but I'd like to open a little bit on the question around children proceedings,
Mm-hmm.
and does conduct get looked at with does it get taken into account more in that context than it does in the financial proceedings?
The court's overriding objective when it comes to children is the welfare of the child.
Yeah.
What's going to be, this, is the best interests. And, there have been children who are, for example, where there's been someone who's has been the aggressor, as it were. The courts will be cautious, but they don't want children not to have a relationship with their father or their mother.
Yeah.
So it's not quite, it's not black and white.
Yeah.
And of course, the standard of proof for sort of conduct in family law is much lower.
Yeah.
It's based on probabilities. The courts will ultimately want the child to have contact with a parent as long as it's in a safe setting. So
Yeah.
I don't know if that answers your question, but in terms
Yeah,
of
I think what I'm hearing from you across both areas is that there is so much discretion and interpretation.
Yeah.
And really, I think that's where I find it very difficult for a lot of my clients to accept is that while something objectively to them and even to their friends and families seems so wrong, actually it may feel wrong to them, and it might be warranted for them to feel wrong about it, but actually the legal system just cannot address that, and it's hard to accept that.
It is. I think ultimately, we know terrible spouses, don't we? And I think a very important part is often a spouse will put down the other spouse in front of their children, which is a form, which is very judgmental to a child's relationship with the victim spouse, as it were. The courts don't like that. They're not going to encourage it. But if someone shows insight, will try and correct things. The child will have contact with them as long as it's safe. And that's where the court would wants parents to come to an agreement, and they want the child to be safe, and they will involve the authorities where necessary. But the fact that a mother has been abusive to the father, not fantastic. There have been some cases where there's been no contact as a result, but generally they will build it up. And I think that's a good thing. I think we're looking at it. It's more holistic.
And I can understand why the courts don't want to go, auditing what's been happening and going to that degree of review of past behaviors as well. So I guess in terms of anybody who's listening to this podcast and who feels that their ex's behavior should really have an impact here and be looked at, but they need that assessment, and I think that's what we've heard loud and clear from you. Then you're somebody that they should call. We'll put your email address in the episode notes, so anybody can reach out to you for that assessment. And as you say, it's an hour of your time having that conversation, but it allows you to be strategic and to understand, what you can and can't put forward as an argument.
Because we know the limitations, but that's not to put anyone off. Absolutely, you need to know that your lawyer's on your side and they've got your best interests at heart. And we'll always give the best assessment we can based on the information before us. And if we think it's going to run and we think they'll be successful, we'll run it. And that's the advice we'll give you. But important to be open to it. But speak to someone quite early on, or speak to a friend, and try and build up a picture as much as you can, and come and speak to a lawyer. Okay.
Perfect. Thank you so much, Naushaba. I'm going to put all your details in the episode notes so people can reach out. And thanks again for sharing all those insights.
Okay, thank you.
Take care.
Thanks. Bye-bye.